Hi, I'm Michael Kuzilny. I've got over 35 years experience in the criminal justice system. I'm a TV analyst on national television and I'm a former police officer. You know, more than 90% of cases in New South Wales are finalised or disposed of by way of a guilty plea, or some say a guilty plea, a plea with explanation. So it's so important if you're representing yourself or you're a fellow legal practitioner to make it powerful, impactful. Tip number one, capture the bench's attention within the first 30 seconds. You know, some lawyers get up there and say, oh, he went to primary school at this school. The first 30 seconds so important. It's a very, very busy court. Bring out the story. Your Honour, my client is ashamed about striking out. He was concerned about the 16 bikies that surrounded him. Something powerful and important, not just reiterating the notes you handed up. Say something powerful and helpful up front. Capture the magistrate's attention early. It's a busy courtroom. Just tender the essentials. Don't bombard the magistrate with lots of paperwork to read. Be respectful. Your Honour, I respectfully tender 2 or 3 documents. Once you get invited to present the plea, don't rush through it. Stand tall, be confident and speak clearly. Acknowledge the offence, show remorse, address the law, address the positive steps you or your client have taken to mitigate the offence, and outline any rehabilitation respectfully. Notes, you know, some lawyers are there, and I see it so often, just reading, magistrates fall asleep. In fact, everybody falls asleep. You know, the most powerful advocates don't even use notes. They speak from the heart. You know, if you can speak from the heart, do that and have a few bullet points. But know that story, know your case better than anybody in that courtroom, and you should, you know. So rather than just reading from notes, won't work. This could really be a difference between winning and losing. Use strategic pauses, you know. You don't have to rush through it like a train. Slow down, have pauses, you know, because the magistrate might want to ask you a few questions, or maybe the prosecutor might want to ask you a few questions. So keep it conversational. And the final thought, powerful and effective pleas are one-off opportunity to achieve a favourable and winning outcome. It could be a difference between getting a conviction or getting a no conviction outcome. So make it powerful, be confident, be respectful, be on time and be organised, and keep it simple. For more information, you can call me on 041 555 7011, and I wish you all the very best with your next court case.